Right. Once again, good evening to everyone. Thank you for being here on a Saturday evening. So why are we doing this? Why did we conceptualize this program for you, this webinar for you? Is very, very simple. I think there's a lot of confusion about the difference between a mediator and a mediation advocate. In definition, a mediation advocate is completely different to a mediator. In practice, a mediation advocate employs a whole different set of skills in comparison to his or her skills that he or she would use in court. So the phrase mediation advocate is not some kind of a mythical figure. It's not a unicorn of the legal profession. So therefore, we said, let's bring you three speakers, three personalities, three lawyers in their own right, who will speak about their experience as mediation advocates, their experience as collaborative lawyers. And we hope that we will be able to bust some of these myths for you today. All right. So getting straight to introducing our panelists, but before I do that, I think there is somebody's audio that's on. So kindly requesting that person to put off the audio. Thank you. All right. I would have said ladies first, but Jacob's the only gentleman on the panel today. So let's start with him. Jacob Alexander is joining us from Bangalore. He is a 2014 alumni of Christ University, Bangalore. In 2017, he pursued a master's in dispute resolution at the University College in London, where he dived deeper into the subjects of negotiation and mediation. He is now based at Crest Law Partners as a lead associate, focused in the firm's dispute resolution matters. He was recently involved in a long, winding, and complex mediation between a large MNC and pensioners, which ultimately he was part of the resolution. So hopefully we might hear some insights from him about this pretty adventurous journey in mediation. Once again, requesting the participant to please switch off your audio or mute your audio, whoever that is. Thank you. Joining us again from Bangalore, Ms. Rukmini Menon. Rukmini, can we have your video on, please? Rukmini is a lawyer with over 3 decades of experience. She's also a director and a senior mediator at CAMP. She's part of the Bangalore Mediation Center panels, the NCLT mediator panels, and of course the Consumer Court mediator panels back here in Karnataka. She's also trained and impaneled mediation specialist at the Singapore International Mediation Center, and also part of the global mediation panel set up by the UNDP for mediating workplace disputes in India. Thanks, Rukmini. Thank you for joining us today. Next up, I would like to introduce you to our colleague from Mumbai, or Bombay, as you like it. It's Juin Nag. Juin is a mediator with CAMP. She loves traveling and interacting with different people. So she also doubles up as our chief evangelist, spreading the word on commercial mediation back here in India. In her past life, Juin has worked in leading law firms of India, including Amarchand Mangaldas, which is now CAMP, and Trilegal, and was the in-house counsel at RBS, BNPP, and SocGen. Juin was the head of legal for SocGen in India before she decided to start her practice in mediation in 2020. Thank you for joining us from Bombay, Juin. And finally, Ashna Reddy, who's joining us from Hyderabad. Ashna will be moderating our session today. Ashna is a graduate from Jindal Global Law School and she has a keen interest in mediation. She has just completed her training as a mediator with Edwards Mediation Academy, and she works at CAMP as a mediation associate. And much of her work at CAMP is basically liaising with our clients, exploring for those who call in to us to explore more of pre-litigation mediation options with us back here. Besides case management, Ashna leads our research assignments and works closely with building client relations with the firm's collaborators. So without further ado, once again, thank you everyone for joining us from different cities and different parts of the country and maybe even abroad. Ashna, over to you. Thank you.
Thank you for that introduction, Jonathan. Hi, everyone. Pleasure to be here among all of you. And before we get to hear the panelists, I would like to talk about why we've gathered here today. So mediation has begun to develop as a mainstream dispute resolution process in India. I say this because India has signed the United Nations Convention on International Settlement Agreements, popularly known as the Singapore Convention. along with 52 other countries. It has become a global trend. And in 2020, the Supreme Court of India formed a committee to draft mediation law. Also, many acts have made pre-litigation mediation mandatory to address pendency and slow disposal rates. One such example is the Commercial Courts Act. So according to the National Judicial Data Grid, we have about 43.9 million cases pending in the Indian courts as of May 2021. And an interesting stat that I came across, I would like to share with you all, is something that I read in the Niti Aayog ODR handbook. And they say out of 16 million new cases that get filed in the Indian courts every year, 8 million that get added to the backlog that we have. So due to our already overburdened judiciary, temporary closure of courts post COVID-19, and the need for speedy resolution of disputes, there is a shift in the dispute resolution mechanism. So mediation has become a preferred first choice. Mediation goes beyond the skills of the mediator alone. Advocates play an active and a very crucial role in the process. A mediation advocate is very different from a mediator, as Jonathan just said. Mediator is a neutral who facilitates the conversation and is restricted from advising or suggesting the client. Whereas on the other hand, lawyers, mediation advocates advise their clients in a non-adversarial approach. They assist their clients through a problem-solving, consensus building approach. They advise clients in reaching the most appropriate and best settlement solution by identifying the risk and reward in solutions, and in general to meet the interests and needs of the client legally. So we can say that mediation advocacy has raised. Okay, continuing. Mediation advocacy has raised the credibility and acceptance of mediation world over, and most importantly, parties feel confident in the presence of their lawyers and are comfortable with their advice in an assisted negotiation. So the type of skills required for mediation advocacy are very different from the skills that the lawyers use while litigating. It is a critical skill in a lawyer's toolbox. And as Gokul always tells me, I find this very interesting. For every mediator or a mediation, we require at least 2 lawyers for the disputing parties. That is a 1:2 ratio. So there is a need for qualified mediation advocates today. And mediation advocacy as a course is not being offered in any law school currently, as far as my knowledge goes. And today we are here to learn the importance of equipping ourselves with this skill set, equipping ourselves with mediation advocacy skills. So on that note, let me open the floor to the panelists. Jacob, I think we should start with you. So in our conversations earlier, you were telling us about the experience you've had while representing a client in a mediation. So would you like to start off by sharing your experience? And also, if you think lawyers play a different role while mediating and while litigating.
Thank you, Ashna. Good evening to everyone. So, well, yeah, I've been exposed to mediation, I think, right from the outset. Having worked at a litigation firm since graduation, mediation was always around the corner. And as a junior lawyer, attending a mediation at that point was vastly different from what it is today. Initially, we were told mediation is more for the parties to talk. There's hardly any role for a lawyer to play. We were told just to go and observe and sort of accompany the client, not really have to do anything, ensure that everything goes smoothly and that the client is satisfied with the entire process, but no active role, so to speak. But I think that's changed over the years. Lawyers aren't just observers anymore. In fact, in some cases, I would argue that lawyers maybe overstep their mandate and speak on behalf of the client without allowing any room for the clients to express their opinions. But I think it's important to draw a fine line, and finding that balance is key. You want your client to engage in dialogue and sort of resolve their disputes with the other party amicably on their own, if possible. But you also want to be there to guide them on some occasions when they've lost faith in the process, and ensure that they stick around for a little longer before abruptly pulling out of the process. So I think that's where lawyers' experience comes in, not only as a lawyer, but also maybe as just a human being, I think. I recall this one litigation, and I think Jonathan spoke about it in my introduction, where we were representing the pensioners of a large multinational corporation. This case was referred to mediation at the appellate stage by the High Court of Karnataka. We had an excellent mediator, very experienced, and the dispute was really complex. There were commercial aspects, there were trust laws involved, rules of the pension association, a lot of things to consider. And this dispute, I think, was already pending for about 20-25 years before that. So both parties had come a long way. And there were at least 3 points in that mediation where the parties felt like they had reached the impasse and wanted to walk away from it. But fortunately, and I think that's also key for any good mediator, the mediator never gave up in that instance. Even though the parties weren't interested, he kept calling us back and really pushed and facilitated a mediation. And I don't think this was a dispute that would otherwise, in my book, be unresolvable almost. But it was a sheer miracle that he was able to do it and end the dispute, because a lot of the pensioners were in their 70s and 80s. A lot of them had died during the pendency of the dispute and would ultimately not have seen the fruits of this decree even. So I think that was a very satisfying experience, both for the mediator, I know personally after having spoken to him later, and as a lawyer to have participated in that process. And I think that really encouraged me to engage in more mediations, encourage lawyers to participate in more mediations, because in situations where you don't think you could reach a solution, you have. And having seen that happen, I think it helps. So far as I think the second part of the question was, are there different roles that we adopt? I think most certainly, yes. As in litigation, I think as an advocate, it's more aggressive. It's an adversarial system, so it's sort of going head on with the other side. But I think in a mediation environment, it's more conciliatory. You need to remind your client of why you're in this process. And generally, the environment is more friendly and, fostering and trying to foster more communication between the parties. So definitely two different hats that you have to wear as a mediation advocate and a litigation advocate. Yeah.
Thank you. That was really nice, very well articulated. Well, you brought out some really good points of how when you reach an impasse, the mediation, it's not that the mediation breaks away from there. There are ways to get back on track, and the mediator in your case definitely did a great job in pushing y'all. Also, with respect to friendly environment, yes, I agree as well. On that note, Rukmini ma'am, you are a practicing tax lawyer yourself, and you've been a mediator since 2015. I'm sure you've mediated hundreds of hours of mediation, and I'm sure you've come across some unskilled. I mean someone who is not prepared or learned enough to represent their client in a mediation setting. So according to you, how does this impact a successful mediation?
Thank you, Ashna. I think Jacob sort of said it quite well when he was talking. Now, when we talk about an unskilled lawyer, we don't mean a lawyer who has no skills per se. That unfortunately that lawyer does not understand the difference between representing his or her client in mediation and in litigation. That lawyer is only trained to argue in court and only wanting to put down the other side and win the case at any cost. So the lawyer, these lawyers who come in for mediation with the same mindset, I would call such lawyers unskilled, because, you know, as Jacob said, is wearing two different hats totally. It's a friendly atmosphere in a mediation. You should be there to sort of understand each other's perspectives, to more willing to listen to the other side. Now, if you do not understand how to represent in mediation, you are not in a position to coach your client, or rather make your client understand what this process of mediation is about and how to go about participating in such a process. So what happens is, neither is the party ready to understand what's happening, nor is the counsel in any way assisting a mediator. And that happens quite often. I would just like to give a short example. It was a matrimonial case where the parties had agreed for a divorce, but the settlement terms, they were really at loggerheads. Like, there was a big, huge difference what was being offered by the husband and what the wife wanted, or what she had quoted. Now, right from day one, her lawyer was very much against the process of mediation. He refused to participate in the mediation, initially saying that it's virtual and he's not comfortable, though the party was perfectly okay. Then every opportunity he got, he would tell the party that, you know, I don't think you need this process at all, and I will get you much more in court. So why? You know, this lawyer did not understand the reason as to why his client wanted to come in for mediation. This poor lady was in quite a sticky situation vis-a-vis her son's education expenses, etc. And she wanted to see how she could tide over this and have enough money to see him through. But this person kept telling her, if you're getting X amount, I will get you 10 times more. And he also said, I'll get you 10 times more after 10 years. I mean, it sounded quite ridiculous when this lady told me that this is what my lawyer says, that he will get me. But she was intelligent enough to tell the lawyer that getting it 10 years hence is of no use to me. I want it now. So she went ahead, she took the decision, went ahead and participated in the mediation without her counsel, did a good job, and they managed to settle. I mean, I was really quite impressed the way she came forward and represented herself. So this lawyer, this particular lawyer falls into the category of a totally unskilled lawyer vis-a-vis mediation. He is very skilled where litigation is concerned, but where mediation is concerned, he has no idea that he has to change the way he looks at getting relief for his party. So that's how an unskilled lawyer who can be a big stumbling block in a mediation, because they try to dissuade their clients from participating meaningfully. And nor do they, if the clients want to even participate, they don't let them. So that's how an unskilled lawyer can be a stumbling block in a successful mediation. Thank you.
Thank you, ma'am. You brought out some really important points about how there is a different mindset in a mediation setting. It's not about winning, but it's about getting what the parties want, understanding why they have come in for mediation at first. And you've defined why we are saying unskilled really well. Thank you for that. Hi, Join. Hi. Join, I know you, and we all heard your introduction. You worked with some corporates, in-house counsels, and you've been part of so many deal-breaking situations in your practice as an advocate. Could you Could you elaborate and share with us your experience with working with a counterpart counsel who's at the table with a collaborative mindset?
Thank you, Ashna, and good evening, everybody. It's great to meet all of you. I'm very, instinctively, I want to give an evaluative answer and say that, oh, it's fantastic to work with someone who's collaborative. But let me decode as to what I understand by a collaborative lawyer, so to say, in a transactional space. I mean someone who's non-positional, right? And someone who's willing to listen and understand the other party's perspective, articulate what her or his concerns are, and then with this knowledge, come at a sustainable solution for the problem at hand. Many of us may think that we are very collaborative, but when I wear my mediator's hat and look at many of the past deals that I have done, and I see that there are many places where I could have improved. I could have been a better collaborative lawyer, and I think that's a part of the learning journey. And I think for young lawyers, the sooner we get the collaborative lawyers' skills in our repertoire, under our wings, the better, because being a collaborative lawyer really accelerates the trajectory. It really helps in the growth of the lawyer. And I would think, being a collaborative lawyer would really, accelerate how you lead a deal. How easily or how soon you are given to lead a deal will depend on your maturity, your, your ability to showcase that collaborative, nature. Now, let me give you, and have I come across collaborative lawyers on the deals that I have been doing? Well, many. And most of the times I've taken those opportunities to learn as to how to become more collaborative. Now, just to give you an example, we often, as transactional lawyers in my past life, we used to sign documents which are called NDAs, non-disclosure agreements. These are very basic documents which you sign before any transaction is started to protect confidential information. Now, NDAs are signed for various purposes. Let us take an example of an NDA which has been signed for a services contract. And in the reality of the world that today we live in, outsourcing is very, very common, right? And when people are signing NDAs, they're very conscious about what they're sharing, and no discloser wants to share their information with the other party or their subcontractors without their knowledge. Now, let's take a situation where there's a positional lawyer, and that positional lawyer has taken a position that the receiver should not be sharing this information with a subcontractor. The reality of the situation is that whatever services are to be performed cannot be performed wholly and solely by the receiver. It has to be subcontracted. Now, if as a positional lawyer, I take a position that, no, I'm not going to allow you to share information, the deal falls through. Whereas as a collaborative lawyer, I understand that what is the most important thing for me is to make sure that that information is shared with the necessary safeguards. So as a collaborative lawyer, I recognize that sharing of information is crucial for me, and I build safeguards to make sure that, well, when the information is shared with a subcontractor, I am informed as to who that subcontractor is, or the subcontractor signs a back-to-back NDA. So how a collaborative lawyer will approach this problem statement that information should not be shared with a subcontractor, and how a positional lawyer will approach is very different. Positional lawyer will say, and many times we have said that, no, this is not allowed. As per my company policy, this is not allowed. Whereas when a collaborative lawyer sees the same problem, that person looks at the problem in a very different light. So it becomes a complete pleasure. It's a complete pleasure to look at and work with a collaborative lawyer, because that person, what he or she does is that person, I keep thinking of a collaborative lawyer as someone who keeps closing lids. These lids are issues which are open, and they keep closing the lids only to the extent that the lids need to be opened. They keep them open and come up with a solution that is sustainable. Yes, to answer in short, I have seen many collaborative lawyers, and it is a real pleasure to work with them, and it's an opportunity to learn. Now, coming back to our question as to how does mediation advocacy training help in me becoming a collaborative lawyer, right? What does mediation advocacy training teach me? It teaches me that it encourages me to foster an environment where I can ask questions and understand the perspective of the other party. It helps me in better understanding my concerns. It allows me that space to better understand the other party's concerns. And with this knowledge, I can come to a good information subset with which I am able to come up with a good decision. So I think, as lawyers go along the journey, it is very important that as lawyers, we bring in the learnings from a mediation advocacy training, whether I'm working as an in-house counsel or I'm working as a dispute counsel, or I'm working as a law firm counsel, to bring in the understanding of a mediation advocate into my everyday skills. And then it transcends from being a mediation advocate skills to becoming life skills of a lawyer. So I think it is extremely important that we recognize this early on and bring in these skill sets in our in the repertoire of our skill sets.
Thank you. That was very informative. You bringing to light how sharing information can actually be productive rather than people taking positional spaces. You also spoke about skills, mediation advocacy skills, and how they're important to us and how it's important to train and acquire that skill set. Right. On that note, Jacob, I actually want to go back to the experience that you shared with us and actually talk about how you have prepared for that experience, right? Like what kind of preparation went in to representing your client in a mediation, intellectually, psychologically, mentally. How did your preparation go about?
Well, that's an interesting question. So obviously there are three limbs to your question: intellectually, mentally, and psychologically. So I think if I were to address the intellectual aspect first, I think it depends on the nature of the transaction, but I would imagine that for a commercial transaction especially, a lawyer needs to be completely on top of the facts of the case. There will be multiple correspondence, various contractual clauses. And I know a lot of you may be thinking, why is this relevant in a mediation dispute where you sort of try and steer clear from facts of the case and not really get bogged down with that. But I think it's important to understand that because it becomes crucial in explaining the dispute to the mediator so that the mediator understands what exactly the crux of the dispute is. It also becomes important for a mediation advocate to be able to digest and absorb some of the proposals that are made and what are the kind of counter proposals you can make. In a scenario where, especially in a commercial transaction, if you feel like you've hit a deadlock and the parties are unwilling to accept or sort of mend their ways and find another solution, I think having an in-depth knowledge on the transaction and how the transaction works helps in suggesting modes of settlement, both in your client's interests and also in speedy resolving of that dispute. In terms of mentally and psychologically, I think this comes into play more so, at least for me personally, in family disputes. There is a mental and psychological element more so to, I think, prepare your client also for what is to come. I think it's important as a lawyer to, and we've discussed collaborative lawyers. Now, it's important for a lawyer to explain to a client before the mediation process that as a part of the process, you will have to make some concessions. There isn't going to be a settlement if you only get what you want. And even if you don't only get what you want, the other party has to feel like you've also given up something. Otherwise, there is no satisfaction. And that's just how any mediation works. So it's important to remind your client and sort of delicately manage those expectations in lowering them from that initial stance that they would have had to bring it down. And I like to sit down with my client before a mediation and discuss, these are our targets for this mediation. This is realistic. This is best case scenario, and this is worst case scenario. So to be prepared for all of it so that the client doesn't walk away from the mediation very early. So I think in terms of preparation, yeah, it's important to sit down with your client and make them understand that this isn't going to be easy. It is going to be a long drawn process. Patience is extremely important. It's important not to give up easily and turn away from this process, and just to have some faith, and also have some faith in the fact that the mediator is an impartial person. There is no compulsion to accept any settlement that is being proposed. And I like to sort of remind them of these realities of what would otherwise happen if they were to participate in the judicial process, as opposed to closing and having a negotiated settlement.
Thank you for that. Well, indeed, when you mentioned mentally, it takes a lot more of preparing yourself mentally to go into a negotiation, because there are going to be deadlocks, impasses, and all of that. That's from a lawyer's perspective. So now, Rukmini ma'am, I want to ask you from a mediator's perspective. What kind of preparation do you appreciate in a mediation lawyer? What are your expectations from them in pre-mediation, during your mediation, and after as well?
That's a very interesting question, Ashna. You asked me about the 3 stages: pre-litigation, pre-mediation, the mediation itself, and the post-mediation.
Yes.
So it's well broken down. So, you shouldn't assume that when it's a mediation, you go straight into mediation without any preparation. That, okay, tell your client, hey, listen, tomorrow's the mediation, let's attend the session. It doesn't work like that. You have to coach your client. You have to sit with your client and make them understand what this process is about. And tell them if they have been in the litigation, suppose they have been in litigation or they have not been, explain how different it is. And explain to them, as Jacob pointed out, that, it's a give and take process. You don't go there expecting to win your case. No, you go there expecting to understand your opponent's perspective so that you could settle on terms which would suit you both. You have to, in the pre-mediation, you have to sort of also appreciate your client's emotional mindset, and you have to ensure that the party is in a position to sort of talk freely, fearlessly in the mediation. So this, it's very important. This pre-mediation is very important in preparing and coaching your client. Now, coming to the actual mediation, it makes such a difference when a skilled lawyer participates in a mediation, because they give us very crisp mediation briefs, which is different from what you put before court. Court could be running into pages and pages, but not in mediation. Make it crisp, set down everything, in a precise manner. Similarly, it's a very common habit. I'm also a litigating lawyer, that we just sort of, file truckloads of documents in any litigation. But in mediation, the counsel should be aware that, file the most relevant of documents, and don't unnecessarily, because you're not going there to argue out your case. You're trying to work out a solution for your party. So sit with your client and see what is most important, based on which you could proceed further. since it's an informal process at any point of time, unlike in court, you could always, produce some other documents before the mediation. Now coming to like you help a skilled lawyer, a lawyer who understands mediation during the process, helps the parties to prioritize their issues. So, you should make them understand, like, what is it which is most important, what you want to achieve from here. You should be able to make your party generate options and negotiate better in a mediation. It's entirely up to the lawyer. See, a mediator is only facilitating the process. The mediator is not telling the party, you do this, you do that. It's up to the counsels. And it's a successful mediation is how a party comes in prepared, and that party can be prepared only if the mediator, if his or her counsel has prepared the party. And last but not the least, the most important in a mediation is, suppose terms and the terms are reached. The counsels should be skilled in putting this down on paper. The terms and conditions of both the parties, both these counsels from both the sides should put it down in a very brief, precise manner, which sort of takes into consideration that the interests and what the parties want to get out of the mediation are put down on paper. That is extremely important. Now, the third phase is post-mediation. Now, you cannot sort of tell your client, okay, agreement reached, now finished. No, you should ensure that, suppose your client, I'm just giving you an example, that the conditions of settlement agreement are adhered to. As a mediator, I really do appreciate when counsels remember and tell them, see, you're supposed to make a payment. Please ensure that the payment is made within so and so time. There is this condition you have to, comply with within so much time as stipulated in the mediation agreement. Please do that. So post-mediation is, basically following up with your party. Following up with your party to ensure that the terms of the mediation agreement are properly complied with. So in all these three phases, it is, as a mediator, what I have seen is a skilled lawyer makes a whole lot of difference when they come prepared and they prepare their client, and so everything goes smoothly. Thank you.
That was some great insight into the kind of preparation and the kind of skills lawyers need to have for a successful mediation, ma'am. You've clearly answered the question to the point, from pre-mediation, during mediation, and post-mediation. Thank you so much for that. Join, coming back to you. Can you mute yourself? Thank you. Juin, we just spoke about how you've worked with corporates, law firms, and you agreed that these skills do come in handy in your previous answer. But going one step further, I would like to ask you, firstly, does having this skill set, mediation advocacy skill set, make you more valuable to your law firm or in an in-house legal team today? Is that something that they're looking for? And further, are they looking for these things in their resumes? Most importantly, are law firms looking at these skills today?
I think if you were asking this question to me about a year back, Ashna, I would really have to crystal gaze, but given the havoc that the pandemic has played in our lives, and the way it has made access to justice so difficult, I would be hesitant to answer that law firms and in-house counsels do not value mediation advocacy skills. Now, what are the mediation advocacy? What are the skills at the core of a mediation? Someone who's a mediation advocate or training to be a mediation advocate. These are active listening skills, These are, understanding the other party's interest kind of skills. These are like, Rukmani said, the importance of being prepared, patience, creativity, understanding that there is a sustainable solution that lies on the other side, of the table, and empathy, most importantly. And I think, probably today we need these skills more than ever. And with the knowledge that most of the progressive, big, small, all law firms are getting themselves mediation ready, I would very strongly believe that not only corporate lawyers in corporate in-house roles, but law firm lawyers need to have this, and aspirants to law firms should have this as an important skill set in under their wings. And why do I say this? Let's look at our adversarial court systems. There is tremendous judicial delay. And what does a mediation advocate do in a setting where parties are not getting access to justice or a resolution in a timely manner? I would think a transactional lawyer who's empowered with mediation advocacy skills would ensure that the contracts that they draft will have mediation as a method of dispute resolution. Now, when that agreement reaches a phase where there is a conflict and that has to go through a dispute resolution or a conflict resolution process, that lawyer may or may not be there. But whichever lawyer is looking at the document will definitely see that mediation is the preferred mode of dispute resolution, and whether or not that lawyer is skilled with mediation advocacy skills, I would think that lawyer would give a lot of importance in seeing that what is mediation? How can I make sure that this dispute is mediated? Secondly, let's look at a dispute resolution lawyer or a lawyer in a law firm who's working in the dispute resolution team. I think it is very important to early on speak to your client and get him or her to understand that mediation is a method of dispute resolution. Because like we know that, maybe that all disputes are not mediatable, but at some point in time in the life cycle of a dispute, there will be a time which is the right time for mediation. And if you have prepared your client that mediation is a method of dispute resolution, you will be able to say with so much more conviction and assertiveness that let us mediate this dispute and see where we come out, whether we come out with a constructive solution. And if you can keep the control of outcome in your hands, we all like control, right? So I wouldn't really think that we would like to give out control in a situation where we are able to come up with a sustainable solution. So I think progressive lawyers must be future ready and have mediation advocacy as one of the skill sets. And law firms and corporates, if they're not looking for mediation advocacy as an essential skill set, they probably are not looking at a holistic picture. So I think it is essential to have this as a skill set and to become that collaborative lawyer, which is the need of the hour.
Thank you, Juin. You brought out some interesting points on how we need to ensure that our future ready lawyers, millennial lawyers, do have these skill set in their toolbox. So while I'm working at camp for the last few months, last 10 months, I have to interact with clients, law firms, lawyers quite a lot. And in my experience with conversing with them, they do understand and value mediation. But most of the times I see that they're reluctant to refer their clients to mediation. And I've picked up some trends. So I just want to get your thoughts on this. So Juin, why is it that some lawyers feel like they may lose a client or they come across as weak if they refer their clients to mediation? You're on mute.
I think that's the elephant in the room, Ashna. And I'm glad that, you asked this question. And, your question is two parts, that do I look weak if I suggest mediation? And the second is that, am I losing my client if I'm, suggesting mediation to the client? First of all, like I said, that only an ambivalent lawyer who understands mediation advocacy, as much as she or he understands litigation and litigation strategy, is able to suggest mediation to her or his clients. And I believe that suggesting mediation to a client is a strategic step in the dispute journey. So it is only possible from a lawyer who understands how mediation can help and when mediation can help, most importantly. And to have that, that kind of an understanding with your client, that your client understands that for you, the center of, you're client-centric, and what you want to ensure for your client is maximum value realization. And once you have that trust relationship with your client, and which is, an essential part of a mediation advocate's, learning, that how to build that relationship of trust, that you're not just doing it, it's not date after date, but it is because you know that this client can realize her or his maximum value. With this mediation, will you suggest mediation as a dispute resolution mechanism to your client? Your client realizes that value. And I don't think it makes you weak at all. It in fact makes sure that your client is well served, a well served client. And we know that there is enough literature to show that mediation is very high in the index of client satisfaction. And a satisfied client means a sticky client, means a repeat client. So therefore, I think we need to get out of this myth, so to say, that mediation makes me look weak. Rather, we should take it as a point of strength, that I'm able to forecast a sustainable solution for this matter, and therefore suggest mediation to my client, which preserves stakeholder value and in fact maximizes value realization, which oftentimes is missed in an adversarial process. Now, coming to the question of whether and I hope that I've answered the question on weakness, and I personally believe it's a matter of strength, it's a matter of strategy to suggest mediation to clients. As to whether I'm going to lose my client or not, and I think this is I've read about it a lot, and I think this is a fear which is best dislodged in the beginning, and the root of this, the reason why lawyers oftentimes feel that I may lose my client is because of the lack of awareness of the importance of the role of a mediation advocate in a mediation table. I believe that a good and we have seen Jacob articulate his role in the mediation table. We have heard Rukmani say time and again how a well-skilled mediation advocate really helps in the mediation table. So it is not that when you are suggesting, mediation to your client, you are leaving her or him dry and saying that, okay, now onwards, it's your journey. It is rather that, you are wearing a different hat then and making sure that your client reaches an amicable, sustainable solution. And I think we need to spread the word on the fact that, mediations, good mediations, complex mediations, mediations which generate sustainable solutions need smart mediation advocates. And the clients see value in that. And when the clients see value in an advocate being on a table, I'm sure, you will not be able to suggest mediation and say that now onwards, it's your journey. So I hope many of us upskill ourselves with mediation advocacy skills. We then suggest to our clients at the right time that this dispute is mediatable and we must go in for mediation. And we must do that with a lot of conviction and a lot of strength. and take that matter to a constructive closure. So that's really how I want to dislodge the fear that being a mediation advocate or suggesting mediation to my client means that I'm going to lose that client. Rather, if the client in the future has an issue, they will come back to you for your strategic advice on their matters.
Thank you for those. And a very different perspective from many lawyers out there, Join. Thank you. Sometimes when I hear these calls or when I hear these thoughts, I'm just all over the place trying to understand how to explain this to many lawyers that I've had this conversation with. But I think you've done a great job in explaining that. I hope lawyers familiarize themselves with how different it is to mediate. It's not being weak, but it's just familiarizing yourself with a whole new process that can bring about the best interest of the clients. On that note, Jacob, we've just heard what Juween said about how they feel weak, but I would like to ask you if you were ever afraid that your clients would think that you are weak when you've suggested you suggested your clients to mediation, or if they might not value you as a counsel or a lawyer. How would you talk to your counterpart counsel or your client if they're feeling like this?
I think Julian really answered my question quite elaborately, and I think a lot of what I will say will perhaps be a repetition, but I completely agree with what she said. I can understand why some lawyers think that way, although I don't personally vouch for that point of view. But let's break it down from this perspective. At the beginning of a case, the lawyer essentially is telling their client that they have an excellent case worth pursuing in court, and that everything they want, they pray for, they will succeed in. So that is this approach that a lawyer will then take a client in while starting a litigation. And this is assuming that we're dealing with mediations post-litigation, not pre-litigation mediation. And then sort of towards the middle, when a mediation scenario crops up, a lawyer then has to suddenly tell his client that, look, maybe we can consider mediation, and along with that, perhaps you need to consider a reduced payout from what I had originally said you should be able to achieve. So there is some sort of contrast there in the perspective or the image that a lawyer may portray to a client before getting into this dispute. But it also goes back to what the role of a lawyer is today. And I think that's, it's completely steered away. Lawyers aren't just today faces of a client in court there to represent their parties in a litigation addressing arguments. I think increasingly today, given the pendency of cases that we have, clients are more open to mediation. At least that's what I feel personally, because of the relative quickness with which a solution can be reached. While I always remind my client, look, there's no compulsion. It's mediation usually gets over in a 2 to 3 month window. If you don't like it, we can always pull the plug at any point before that, or it's just 3 months. You have nothing to lose, considering this is a long race in court. You're looking at least 5 to 6 years. So this 3 months is not going to affect you in any manner whatsoever. And I think our role as counsel is to give a client good counsel, to advise them properly on the strengths of their case, explain the uncertainty of the judicial process, that even if you have a great case, there's no guarantee that you're going to succeed. There's always an appeal process. Cases can be languishing for many years. And it's important then to give them that good advice and sort of remind them of the realities of their case. And I personally believe that in a situation like this, if a mediation is successful, even though a client may have to take a reduced payout from what he originally imagined, like Julian said, there is definitely credit that a lawyer will get for the good advice that you're giving. It builds your relationship with the client. There's more faith and trust in your process. You may have lost one brief, but ultimately, if the client is satisfied, it could bring in more briefs for sure. So I would think that there's no reason to think that or have any fear in participating in a mediation process as a lawyer. In fact, it's an opportunity for you to show another dimension of your skill sets and really show that by using that skill set, you can bring a very quick solution to a dispute which otherwise take many years to go. So I hope I've answered your question.
Yeah, and I think you've also addressed and brought up a very important point that most lawyers are scared or worried. You've debunked that myth completely about the reduced payout that lawyers feel that they will have. That I think from my conversations with lawyers, that's one of the biggest concerns, apart from the fact that you mentioned that they can't represent in, they can't pursue litigation or arbitration once they've entered mediation. Rukmini ma'am, my question to you is, if actually Jacob kind of mentioned this, that once you enter into a mediation, lawyers feel like they cannot pursue litigation or arbitration, but do you have anything else to add to what Jacob just said?
Yeah, I'd just like to add a little bit, but before that, Jacob and Juheen, mentioned something which I'd like to highlight upon, that, you gain your client's trust. I'm just highlighting an example. Consumer forum judge was telling us that there was this young lawyer who appeared before him when he was a district judge. Appeared before him, very young person. So he looked at the case and said, no, take your client for mediation. So this boy turned around, this young counsel turned around and told the judge, Lordships, if I take my client to mediation, and it gets settled, I have no other cases. So what do I do? Don't do this. So the judge still insisted, no, please go. So then he referred this, and then after a couple of months, the same lawyer appeared before him and looking definitely more confident, happy. And he made it a point to mention to the judge that, sir, you had referred a case of mine to mediation. And it so happened that was it happened to be a bank case or something like that, where he was on the panel, and they were so happy. They were so happy about it. The client was so happy the way it got settled in a very short period of time, and they got a very good settlement that they gave him so many more files to represent, and they became very ardent followers of mediation. I just wanted to add this. And to add to what Jacob said, I just want to say that most lawyers feel that if you're in the middle of a litigation, how do you suggest mediation? Because you would have said something and now you're suddenly changing track. So, but, what I have noticed is that as a lawyer, what I've noticed is that parties suffer from fatigue after spending a couple of years in courts, and then they get so fed up. They say, like, when are we going to see an end to it? So they are always very happy to hear that there is something available for you. Try it out. There's no harm in trying it out, because if it doesn't work, it's not that that's the end of the road for you. You always can go back to court. You're not going to the doors are not closed for you. So it doesn't matter. Even in an arbitration, that could happen, that in the middle of, there are arbitrators nowadays who do in an arbitration tell parties that, it looks like it could be settled. So why don't you try a mediation? Now, one thing I'd like to mention here is, if it's a skilled lawyer, and there is always place for all these three modes of dispute resolution in your practice, be it a firm, be it an individual, be it, in litigation, arbitration, and mediation. As a counsel, you should know how to filter cases, and you should know what to put in which bucket. And you should, I think Join mentioned this point, you should know which time. See, all cases are not amenable to mediation. It's not that each case which comes to you, you say, okay, go for mediation. That's not possible. There are certain interpretative cases, the cases involving interpretation, policy, etc., which have to go before court. Now, there are some parties who want justice, you know, so those are the parties who should not be referred for mediation. But you should know the right time to refer them to mediation. So I think I have answered your question as to it at any stage, and it's a myth that, you know, if you go in for any other mode, you cannot come into mediation, or the other way around, that if you come in for mediation, you can't go out again. No, that's not so. The doors are always open for you if mediation does not work out, either arbitration or litigation, whether it's in the middle or before you start with the litigation.
Thank you, ma'am. Yeah, you have answered my question. Thank you, Jacob and Join. You've all shared with us your experiences and perspectives from your real life experiences. That's really valuable to us. And we've talked about how mediation advocacy we've established that it's an important skill set. I think after this conversation, we've debunked some myths. And I think it was a really good panel that we've had. Those are all the questions I have from my end. I'm sure after hearing you all, we have some questions from some of the participants that we have today. I think it would be great to open the floor to them for some questions.
I think Ashna, Mr. Merchant, Amin Merchant had put up his hand for a question.
Yeah. So would you like to unmute and ask your question? And Gokul, you can take over if you have any questions in the chat box as well.
Thank you, Join and Rukmini and my friend Jonathan. It was a pleasure hearing all of you. Just a few thoughts, a little bit out of the box. So to actually make mediation a success, what I would think is that law firms, rather than having only advocates who have to change their mindset from adversarial litigation, I think a mediator on their board would also become a good advocate in mediation. So I'm sorry, I'm not putting on my video, but I can put it on my video. Just a second. I'm driving my car. It's okay. So I personally feel is that if I'm a mediator, if I get onto the board of a law firm, I will take the help of all the lawyers who are there to help me, to guide me through the nitty-gritties of the law, to be on the right side of the law because of a mediation settlement agreement. What are the draftings that have to take place, and what are the points of law that have to be, so that it's an effective and an executable mediation settlement agreement. Whereas having a mediator on board who's not actually the mediator of the case, but actually getting a mediator to become an advocate in mediation would help the cause of the law firm and would also open the eyes of the young advocates who are watching the mediator who's actually practicing advocacy in mediation and see, yes, we can be resolution oriented rather than adversarial. That was my only limited point. Thank you. Thank you for the time. Thank you for your time.
Thank you, Mr. Merchant, for sharing that opinion. There are a few more questions that have been posed to us. And our panelists, feel free to jump in and answer this question at any point of time. One of the questions that has been posed by our participants is, even if one, and this has more to do with mediation in general and less to do with advocacy, but it's a relevant question. Mediation, I'm ready and willing to participate, but the opposite side and their advocate is reluctant. So how does mediation? The question seems to suggest that that's why it's so easy for mediation as a process to get derailed, because it can very quickly opt out of this process because it is so-called voluntary in nature. At any point, an individual can just opt out and then derail the entire process of mediation.
Gokul, if I can just back your question up, because you were in and out
you were in and out
on your audio. So I think the panelists, the question for you is, since it's a voluntary process, a lot of lawyers feel like, there's no point attempting this because at any point of time they can walk out of the door. And therefore, what does it take to get the other side to invest into mediation as much as you want to do that for yourself and your client, right? And I'll add a second part of this question because we also want to make good use of time, is since it's a voluntary process and since someone can walk out, there's also the confidentiality part that comes in. And there are a lot of lawyers who feel like, oh, we now participate in this mediation. We've shared so much about our interests and our positions. And then the other side really does not participate in good faith and walk out. So if you can handle this combination of the confidentiality and voluntary nature of mediation, any of the panelists, if you can have a quick take at it, that would be nice.
Jonathan and Gokul, are you sort of, is your question around as to how would you get in? It is a voluntary process, or how would you get, if suppose I come in for mediation and I get my client in to sign in for mediation, how do I get the other side, right? To agree for mediation, since it's a voluntary process, right?
Correct, because you feel like the other side, or that the other side does not want to participate because they think it's a voluntary process, and therefore you can walk out at any point of time.
Okay.
It could be the other way around. It could be both ways. It could be either convincing your client or convincing your counterpart counsel.
Okay.
So let's address both.
Okay. So if I can go first on this, I'd just like to say a few things. That first of all, when you're speaking with your client about a particular case, and if it's even before a case has been filed in court or before for arbitration, you, as I said, leave the choice of the mode of dispute resolution to the client by making them understand how these processes work, and give them a very clear picture of how long it takes in each process, how does, about what happens in each process. For example, litigation and arbitration are known to be very expensive and time consuming. So explain all these factors, do what is called what we say in a mediation, a reality check with your clients, explain it to them. And since at the end of the day, it's what the client wants, so let them choose. But to help them choose, you have to explain everything to them. Now, when going over to the other side, as a counsel, you should reach out to the other side, and especially if you've been in, I've seen cases which have been in court for some time, and as a counsel, if you reach out to the other side and say, listen, why don't we, it is no doubt a voluntary process, but at least let's try this out. It's not going to take us very long. It's not that, this delayed litigation, 1 or 2 or 3 months, if we devote to this mediation, it's going to harm our respective parties in any way. And, get in, buy in the other side, by telling them more about the process if they're not aware as to how long, how it would be advantageous for their party also to participate in mediation without in any way adversely affecting their interests, say, in litigation. So that's the way you can do it. And then coming to the aspect of confidentiality, it's a very important aspect. Most people think that because you are in a mediation, you reveal so much. And then tomorrow, if it does not work out, you to go back to court. That confidentiality, what will happen? We know so much about each other's, we know each other's stand. We know so many facts about, is it going to adversely affect us? No. If you participate in good faith, first of all, in mediation, the principle of confidentiality is there, saying that you cannot rely upon any of the information. What is in mediation stays in mediation. You cannot rely upon any information revealed in mediation in your court process. And so it is, this confidentiality is in fact helpful in the long run, because mediation being a process where the parties are coming out with a lot of facts, it helps them in the long run in case mediation does not work. And confidentiality is maintained because the mediator and the counsels inform the parties that they cannot rely upon information which they have come across in the process of mediation. Thank you.
Thanks for that, Rukmini. Is my audio clear right now, or is it breaking up again?
It's okay now.
All right. So another question that's come up, and this actually has to do with a lack of understanding, and it's a very good question. Lack of understanding of the difference in the skill sets required between a mediator, between an advocate who's representing a client in mediation and a litigation advocate, as in, is just one second, is bargaining a part of the tools that are available to a lawyer in mediation? So, because at the end of the day, the question seems to suggest that the lawyer's job is to represent the client in the mediation. Since unlike the process of litigation, the lawyer takes a back seat, over here, how does bargaining actually take place? And at what point of time does the lawyer decide that mediation may not be the best option and litigation should be opted for? I know it's a very big question that's been asked, but I thought it was very relevant in terms of what we're discussing.
Gokul, I could answer this, but I would like Jacob to come in here. He's represented quite a few of his clients in mediation and in litigation. So let's see what he has to say. I'll just add into what Jacob has to say. Jacob, could you take this, please?
Yeah, of course, I'd love to. Great question, Gokul. Now, to my mind, the bargaining aspect, it really depends on the capability of the client also, who you're representing. Now, some clients are more capable, some clients are less capable. And I think the role of an advocate will really change in that scenario. Now, if a client is more on top of his case and able to fairly and strategically negotiate his case, and I think a lawyer's position then is more to sort of rubber stamp that if he knows what he's doing. But in cases where a client is completely dependent on their lawyer, that happens quite often, in fact, which is also why there is a lot of fear around mediation, because parties don't know what it entails exactly, and they don't want to participate in it. So they're completely reliant on a lawyer. So I think in those situations, yeah, bargaining is an important tool. It's extremely important to be able to, and as I touched upon earlier, having the right know-how on your case and understand it completely, to be able to bargain in the right manner and understand what concession won't hurt your client. Because it's important to make some concessions in a mediation. If you don't make a concession, there isn't going to be a settlement. So having that know-how and experience from a lawyer's perspective to understand where I can make a concession and where I need to ensure that my client's interests have to be protected, fair amount of bargaining that happens in that circumstance.
I understand that perspective, Jacob, but can I just follow up with another question?
Yeah.
This is tying into something that Ashna has already discussed with all of you, but just to make it clear for all our audience, whenever, and this is something that I have faced as a mediator as well, whenever there's a suggestion even made regarding a sort of and I actually specifically don't want to use the word compromise, because it's a negative term, but any kind of concession that needs to be made vis-a-vis the other party, the first reaction that most litigants, at least in my limited exposure, people have is, maybe my lawyer is not good enough, without understanding the process of mediation. So, and this brings us back to the kind of preparation that all of you were talking about in bringing the client to the mediation table and therefore prepping the client before bringing her or him for mediation. Now, is this something that you have faced also, wherein as soon as you're talking about the idea of a give and take, balancing that with self-determination and the idea of self-determination? So how do you balance all?
That's a great question. So I have, in fact, faced these issues with my clients quite often, where there is an element of mistrust, where a client feels that perhaps you are compromised, perhaps you are not really putting forth their case to the best of your ability, and that maybe there is some element of bias. And this happens, of course. And I mean, in situations like that, if there is, I always believe if there's not enough trust that a client has in your ability and your process and your integrity, then that's never going to be a working relationship, both in mediation or in litigation. So, but to also answer your question, how do you prepare? How do you bring your client on board? I like to remind them of, like, as I've already touched upon before, the realities of what he is likely to succeed. Use my experience to explain that even the best case scenarios, and give them examples of cases where I've fought for cases who have excellent cases and I've still ended up on the losing side. So having that certainty of a settlement which you can enforce tomorrow, immediately after the settlement is done, is much better than having a maybe solution with possibly a higher payout at a later date.
Yeah, that makes a lot of sense. Thanks, Jacob, for that.
I just want to.
Would you want to add something to this?
Yeah. I just want to come in here. You know, it's quite possible that the client, that's why, as Jacob correctly pointed out, that preparation matters a lot for mediation. That you have to tell your, when you're discussing with a client, show him reality. Don't always say that, you have 100% case which you can win in court. Don't worry about it. I will make sure. No, that's not the way. Point out some hard facts to the client. Say that, yes, you have, but remember one thing. If we do go in for litigation, there are appeals and appeals and appeals. You are not sure where you're going. When is this litigation going to get over? And at the end of the litigation, you're still not sure what you're going to achieve. Whereas somewhere down the line, if your client, as Jacob said, trusts you enough and realizes that, what's the point of getting 50 lakhs 15 years ahead, whereas what I may get a lesser amount today, but at least I have seen closure of my case. Maybe it's a business relationship where I can still continue on in business with my opponent, where I don't have to spend so much on litigation. I can time-wise, I can concentrate more on my business and don't have to sit and worry about this case. So all that is very important to understand, from make a client understand. So that helps a lot.
I completely agree with you, Rukmini, but I'm still skeptical about this kind of a conversation being had by an advocate with the client. A mediator in a mediation setting can always explain this to both the parties, that continuing with an adversarial approach in which the right of determination of a dispute is handed over to a third party, dispassionate third party, but still handed over vis-a-vis retaining control of the dispute. I can explain that from the perspective of a mediator, but having this kind of a conversation as an advocate, I would feel would be far more, you'd have to be far more tactical so as not to come across as not being confident about the case. Because a given over here is India as a process is used to the adversarial approach. In India, we are used to the adversarial approach. The entire concept of collaborative dispute resolution is alien to us in terms of any serious dispute resolution process. And therefore, most litigants that come in also face similar kind of predicaments. And therefore, the lawyers accordingly face these issues. Juin, would you like to add something regarding your experience in the corporate world or generally with respect to this question?
I was just, as you were speaking, looking for a quote that I had shared with Rukmini, Jonathan, Ashna. And it said, if you give me a minute, probably I can look for it. But it said that, the past is no longer yardstick for the future. And this was said in the context of climate change. And I think all that you are saying, Gokul, that we are an adversarial system, all this was true. And I keep bringing it to the pandemic because the pandemic, I believe, has really refocused our lens. It has really, shown us the mirror and refocused our lens in terms of, what is important today. And time and money are the two most important resources in the hands of business corporate India today, or for that matter, for any dispute, right? So it is very important that we kind of shed that mindset that adversarial way is the only way to get to a solution, and start believing that having control over the outcome and you curating the solution that works for you is the way to go forward. So I would urge that all of us, having attended this session, should be equipped with the understanding of what mediation is, what potential it holds, and to spread the word so that we start seeing value in mediation, and mostly in commercial mediations, because there is a lot of value which remains unlocked today because the cases are in courts, right? And adversarial way of looking at commercial disputes is very, I would say, business unfriendly, because you come up with a resolution maybe 5, 6, 10 years down the line where like Rukmani was saying, that 15 lakhs doesn't hold any value. But whereas you can take control over that outcome today and get it to a resolution which works for you, I think that gives you a lot of certainty in terms of what you are looking at. And I would think that with the uncertainty that we have been thrown into, we will really not take the past adversarial mechanism as being the only way of getting a resolution as the yardstick of measuring what the future holds. And we are able to come out of that cocoon and look at a bright, sustainable, creative future.
Correct. Thank you so much, Juin, for your inputs. We don't have too much of time left, so I'm going to bring in my colleague Jonathan to take over and bring to an end this session. As usual, if you have any, however, I'm just going to leave you with this thought. If you have any questions which we've not been able to address or which we've not been able to ask, feel free to write into...
I think Gokul, sorry to interject. There was one question which Vasundhara had forwarded to me. And I think I did answer her, but I would like to know if if she's comfortable with that being discussed now.
Sure, we have the time. Go ahead and do it.
Yeah. So I think her question was that does a mediation advocate?
Juin,
sorry, Jonathan.
If you can give me 60 seconds, please, and I'll let you address.
Go ahead, Jonathan.
All right, thank you. So I've just put in the link to the feedback form in the chat box to everyone. Please help us fill this up, because it's going to help us take this message forward. We believe that all of you who have joined us today, we had around 65 of us at the start, almost till the end, and the 44 of you who have still stayed with us. Thank you for staying with us. You're all part of this journey, helping us take this message out. There is a huge event that's happening in 2 weekends from now. On July 17th, the Chief Justice of India and the Chief Justice of Singapore are speaking at the India-Singapore Mediation Summit. I'm going to send you the link to the summit. You can register right now. It's, of course, a free participation and a free registration. This is a monumental event for India, for commercial mediation in India. And therefore, I think it would be nice to see all of you there. Please spread the word. It's an open event to anyone and everyone who's interested in helping take forward mediation in India. We are still at a very, very nascent stage, but we are making huge grounds, and Juin's going to address this very important question next. But stay with us and help us take this message forward as much as you can. When a client does come to you, you hear words like retribution and justice and payback, and how do you work with all this very hostile terminology? And Jacob spent a lot of time talking to you about how he would work with his clients, but it's still a long way forward, and we hope we will get there in time. But as much as we remain as a community that's putting this together and taking this forward, I'm sure we will find a way for mediation to really progress in India. Over to you, Juin.
Yeah, so Vasundhara had asked me an important question as to how the mediation advocate then, and the way I understood it, represents both the parties in the mediation table. I just want to clarify for the benefit of all of us, and I'm sure you've heard this, time and again from Jacob, Ashna, Rukmani, that the mediation advocate is still the advocate for the client. He or she still represents the client at the mediation table. The mediator is a neutral, independent, facilitator for the facilitated conversation. So it is not that if you suggest mediation to your client, you are taking, you are taking yourself off the case and you are becoming the mediator. You still represent your client in a collaborative dispute resolution mechanism, not necessarily in an adversarial dispute resolution mechanism. So I hope, Vasundhara is there and I've been able to respond to a question.
Yes, ma'am.
Jonathan, can I ask you a small question? Is it okay, Jonathan? Will you be able
Yes,
to?
Mr. Merchant, please go ahead.
So, what I was thinking is that if there is a law firm and they've got advocates in their law firm and they've got a client who they want to recommend for mediation, would it be advisable to call in a mediator? Because as I was hearing the conversation, an advocate may not be able to go back on what he's actually suggested to his client and go back in terms of winning, losing. There's so many commitments that are made in adversarial litigation. So to take the whole matter forward to mediation, would it be advisable to bring in a consultant mediator to communicate to the parties, look, this is how the whole, after doing some evaluation in the law firm, and then take that particular case to mediation? I'm just trying to put things in perspective. Jonathan, any merit you see there?
Fantastic question. I mean, absolutely. So if the lawyer has already had a conversation with his client and which did not address mediation early on, and he does or she does see the value in mediation now, that's what we exactly do back here at CAMP, right? So when we have cases coming in which are already in litigation, which are already in arbitration. Sometimes the judge refers it to private mediation. Sometimes the lawyers bring it themselves. And I completely get your point. And that's a fantastic point. Sometimes it's very difficult for a lawyer to actually take that word out to their client and address the mediation aspect. And that's what we do. And that's what we're happy to do. So you can always reach out to us and say that we would like you to orient. And I would use the word orient very, very specifically there, because we cannot be coercing, we cannot be forcing, we cannot be convincing Jacob's client to mediate. Jacob, I'm just going to use you as an example here. But Jacob can call me up and say, Jonathan, can you speak to my client about mediation and explain the benefits and advantages? Absolutely. And we would love to do that. That's a great idea. You can absolutely call in the mediator to help orient your client about mediation.
Thanks.